Thank you for watching this video brought to you by Prosecutors Center for Excellence National Best Practices Committee. My name is Sophia Roach, and I'm a senior attorney with PCE. This video is part of our caseloads presentation, and today we're going to be talking about sufficiency in prosecution. I would also urge you to take a look at some of the sufficiency videos that are dedicated to specific types of caseloads, including domestic violence, sex crimes, narcotics crimes, fraud, as well as homicide. What is sufficiency in prosecution and why does it matter? Sufficiency is the amount of work that is required to satisfy a standard of due diligence in accordance with state and federal law, local mandates, and community expectations. It's what we need in order to move forward with a case, complying with our ethical and legal duties. And that's important because we oftentimes measure our volume of work by cases, but understanding what that volume actually is very difficult and obviously varies significantly depending on the type of case. When we look at basic prosecution requirements, they have expanded dramatically with the advent of digital evidence, body-worn camera, social media, etc. We now are in a position where whether we are issuing a case, sending it back for additional information, or deciding not to issue a case, there is a significant amount of work that's being done on the front end in order to review various types of evidence that are coming with a case. It is no longer just a brief police report. It is oftentimes a significant volume to review. Now, when we look at what these initial documents are that require analysis, we're talking not only about investigative reports, but laboratory reports. As we move further on in a process, we may be looking at defense and expert reports. When it comes to media, we have a wide variety of media, which may have to be reviewed by a prosecutor, some of which is extraordinarily time-consuming. And of course, there's also other types of evidence which a prosecutor, in order to comply with their duties in proceeding forward toward a trial or disposition, has to evaluate. And those things include impounded evidence, subpoenaed records, and now we have even new digital tools such as license plate readers, gunshot detection system data, all of which needs to be reviewed by somebody who understands the technology and the importance of what that technology can tell us with regard to a particular case. Once we move along in our case preparation and we are preparing for some of the initial proceedings, there is a significant amount of work that goes into either a grand jury or a preliminary hearing. If that proceeding moves forward towards trial, you can see that, again, there's going to be additional evidence to review, witness contact, preparing motions and exhibits, arguing those, and ultimately going to trial, and if there's a conviction, preparing for a sentencing hearing. Even with a plea, there is significant work that goes into preparing and conducting a sentencing hearing, including contacting victims and witnesses who may have an interest in the ultimate outcome of the case. This is all to say that the amount of work that is required, regardless of the ultimate disposition of the case, is quite significant. And so when we talk about a case in a caseload, we are really talking about hours and hours of either one prosecutor or multiple prosecutors' time. Now, when we talked about sufficiency, we noted that there is going to be some regional variation. This is the community's expectation, and that does differ depending on where we are in the country and what the resources are that are available to us as prosecutors. And we urge prosecutors to take a look at acquittals and mistrials as kind of a key to understanding what those community expectations are. They can speak volumes to us. Consider surveys, talking to jurors when appropriate, making sure that your prosecutors are drafting post-trial memos when there are either acquittals or mistrials, so you can try to understand what is missing and make sure that that sufficiency standard is satisfied the next time around. And most importantly, sit down and debrief the cases so that you can understand as a team what could have been done better, or perhaps whether or not community expectations would indicate that this particular type of case is not one that the community is prepared to accept. We've got to learn, adapt, and train. We want to make sure that we have solid issuing standards in our offices so that people understand what is required in order to issue the case, the types of evidence, the quality of the evidence. We need to make sure that we are training lawyers on both direct and cross-examination as they continue and progress in their careers and take increasingly serious cases on. And finally, closing argument. This has been a brief chat about sufficiency. I thank you for your attention, and please take a look at some of the other videos for case-specific sufficiency in particular caseloads. Thank you.